Welcome to the Alsandor Law Podcast, your go-to resource for demystifying family law with experience and empathy by your side. Hosted by attorney Cheryl Alsandor, founder and lead attorney at the Alsandor Law Firm and a board-certified family law specialist. Together with attorney Cheryl, delve into the intricate world of divorce, child custody, and more, sharing valuable insights, expert interviews, and real-life stories to support you on your family's legal journey. No matter what challenges come your way, our team is here to guide you every step of the way. Join us and let us help you find clarity amidst the legal maze, paving the way for a brighter future.
I want custody. I hear that at least once a week. I hear someone say to me in a strategy session or a consultation that I want custody of my child. So today we're talking about what it means to have custody of your child so you'll know what it means and how to obtain the relief you're seeking. So what does it mean? Well, I'm Cheryl Alsandor. I am a board-certified family law attorney from Houston, Texas, and today we're going to explore that very issue. So why is it important to know what it means to have custody? Well, if you're facing a custody challenge, you're going to want to communicate to a lawyer what you want and what you need. And so if you're using the right terminology, it's going to help you to communicate with the lawyer. It's going to help you to communicate with the judge. It's going to even help you to communicate with the other parent and work out an agreement, if possible, with the other parent. So it's really good to use the right terminology and to know what you mean when you say, I want custody, especially in the state of Texas. If you also know what the right terminology is and really what it means to have custody, you're going to be able to set proper goals for yourself. And a lot of times I have to redirect clients, and we'll talk about that a little bit more. But I have to redirect clients so that they can have realistic goals when they're asking for custody of their child. And if you're using the right terminology, you'll be able to better participate in your child's case, and you'll feel less like a victim. You'll feel less vulnerable, as if the judge and your attorney are making all the decisions and you're just sitting there not knowing what's going on. So, with that, let's just talk about what conservatorship means. Conservatorship, well, I thought we were talking about custody. Well, in the state of Texas, we don't really use the term custody. It's not the legal term. The legal term is a word, conservatorship. And for other states, conservatorship has to do with guardians and other stuff, but not in Texas. Texas really, conservatorship has to do with the rights and duties that a person has to a child. And there's three types of conservatorships. There's sole conservatorship, and there's joint conservatorship, and there's possessory conservatorship. So a lot of times when people come to me, they say, I want sole custody. And I'm thinking, do you want sole conservatorship? Okay, so let's break that down. So conservatorship, again, has to do with the rights and duties that you're going to have to a child. And so conservatorship affects things such as, where does your child live? Who gets to determine the child's primary residence? That one's really key. I think for most people, when they talk about wanting custody, they're really talking about where their child is going to live, or who's going to determine where they live. And usually it's the person I'm talking to. It's usually that client who's saying, I want to have custody. I want to determine where my child lives. In Texas, we say that is the right to establish the primary residence of your child. And sometimes we'll use the phrase primary. You want to be the primary, okay? And so if you have the right to establish your child's primary residence, then pretty much in layman's terms, you're the one who's got custody. But there's some other rights that go with being a conservator. There's the right to make elective surgery decisions. So not life-threatening decisions, but elective surgery decisions. Oftentimes with teenagers, what comes up is scoliosis. They're, 15 years old and they're very active on sports, but they've had this back issue going on. And the doctors are like, look, we've got to have surgery while they're still a minor, or once they reach adulthood, it's going to be a lot harder. Elective surgery. It could even be taking wisdom teeth out. Elective surgery. So who's going to make those elective surgery decisions? Who's going to make psychiatric and psychological decisions? That's a big deal. Psychiatric decisions include medication. A lot of parents, they don't want their child to be on psychiatric medication for a lot of different reasons. All of those decisions have roll into conservatorship. There's also educational decisions, legal decisions, managing your child's money. All of those things affect and are a part of conservatorship. So when a parent is a sole conservator, they're making all of those decisions by his or herself, and the other parent has no decision making. So when a client comes to me and they say, I want to be a sole conservator, I'm thinking, oh, you want to make all the decisions yourself. You don't want the other parent to make decisions. And so then I start to explore that with the parent. Why do you want that to happen? And who's been making those decisions in the past? All of those things are factors in who should be, whether or not there should be a sole conservator, or whether or not there should be joint conservatorship. So that's the other option. Our family code tells us to start with joint conservatorship. That's sort of like ground zero. That's the presumption. The presumption is that mom and dad, you all are going to be joint conservators. Let's start there. And so if mom and dad are joint conservators, that means most of the time they're sharing in a lot of those decisions, which I think parents are supposed to do. They're sharing in whether or not their child will have an elective surgery, or whether or not their child will see a therapist, or hey, the child's making money, on YouTube. Who's going to manage that money? So when parents are joint conservators, they're sharing the decision making. And that sharing can look a lot of different ways. It could be that they're making decisions together, like, unless we agree, it's not happening. Or it could be they're sharing in the sense that they're independent decision makers, meaning, hey, I can make that decision without you. You can make that decision without me, but we both have that power. So that's another way of sharing decisions. We call that independent decision making. I've got power, you've got power, good. Joint decision making is we've got to agree or it's not happening. Okay. And then there's always that exclusive decision making where one parent is making that decision. And I always tell clients you can mix and match those. It could be that one parent is making the exclusive decisions when it comes to education, but when it comes to invasive medical, maybe another parent's making exclusive decisions, or you're saying, hey, that one's going to be independent. And so that is, knowing the terminology helps you to figure out what kind of rights and decision making each parent should have. Maybe one parent is better at managing money and the other one's really great at making medical decisions. And so in an ideal situation, you allocate to the parents what's going to be best for them and ultimately what's going to be best for the child. Okay. Now there's two rights I really want to emphasize, and that's the right to establish the child's residence, because I was saying before, you can kind of mix and match. There's exclusive decision making, independent decision making, joint decision making. But when it comes to your child's residence or a parent's child's residence, the residence has to be established by one parent, unless their parents agree to do something else. Okay. So there's usually one parent establishing the child's what we call primary residence. Sometimes I tell my parents, well, look, your child really has two residences. There's your residence and the other parent's residence. So one parent's going to have the primary residence and the other one's going to kind of have the secondary residence. Okay. And so one gets to establish the primary residence, and the person who gets to establish the primary residence also gets to receive child support. So you can imagine that there are a lot of fights in the courthouse about who's going to be the primary, because if you're the primary, you're receiving child support. And if you're not the primary, you're likely paying child support. And so you can mix and match these rights and duties. Parents can be joint conservators, yet one of them is still the primary joint conservator. And so that kind of throws parents off a little bit. When one says, I want sole custody, then I have to stop and think, sole custody, do you mean you want to make all the decisions for your child, legal decisions, educational decisions, residential decisions? Or do you mean you want to establish the primary residence of your child? And so that's why it's really important to know the terminology so that you can set proper goals. You can communicate to your lawyer, to the judge, even to the other parent, what it is you really want and what you're trying to do. So that is a mouthful. Any questions? Any thoughts so
Oh,
far?
yeah. Yeah. And for those that don't know, my name is Brandi Spaich. Kind of just here as a bit of a guest, a co host at the moment. So I know we were talking about the when you're doing the sole conservator, how would the court kind of figure out which parent should be the sole
Yeah, that's a great
conservator?
question. That's a great question. And I will say if the court is having to figure it out, that means you've tried to reach an agreement. In most courts, and especially in Harris County, Texas, and Fort Bend County, Texas, where I practice, Brazoria County, they don't require mediation so much. But Harris County and Fort Bend County do require that you go to mediation if child issues, if there's conservatorship issues that need to be dealt with. And the court sends people to mediation because a lot of those issues can get settled in mediation once you talk about them. And so if you're going to see a judge, it's because you went to mediation, you negotiated those issues, you were working with a professional family law mediator who heard the other side, who did their best to help you all reach an agreement on allocating those rights and duties between you, and it just failed. So if you're going to see a judge, chances are you've got some pretty strong issues or pretty strong reasons why you couldn't reach an agreement. And so the court's primary concern is to consider the best interest of the child. That's what the court wants to do. And I always tell my clients, I said, look, I hear what you're saying, and I'm going to fight for you, but the court is going to be looking and caring the most about your child. That's what they want to do. Children first, and then parents, okay, you're second and third.
Mm-hmm.
And so the court's going to be considering, what does your child need? Does your child have any extraordinary needs, any medical conditions, any therapies that are needed? Has there been anything that happened in the child's life, any trauma in the household, anything that the child has seen that has caused harm, anybody in the household that has hurt the child? What does the child need? And a lot of that's dependent upon how old the child is. An older child, a teenager, is going to be able to tell the judge what they need much better than a toddler or even an infant. And so the judge is going to take into account the child's needs, the age of the child's educational needs, the goals of the parents for the child, as well as the court's going to also take into account the physical and emotional needs of the child as well. And so, and then also the ability of the parents. That's huge. And that's where a lot of mudslinging sort of happens, where the parents start attacking each other's parenting abilities. And so you start wanting to consider the historical ability of the parents to parent. What have the parents been doing in the past? Who typically, got the child up in the morning time, got breakfast going, got them off to school, helped them with homework, took them to the doctor, took them to extracurricular activities. Who was the nurturer? How do you discipline? All of those things are factors in determining what's in the best interest of the child. And so to do that, if you're headed to court and the judge is going to make a decision, you might be needing to bring teachers. You may need to even, subpoena a therapist or a doctor, but that gets pretty expensive. Friends and family members, those people who know the child or who have witnessed the child with parents or who have heard the child say things, all of those different types of elements play into determining, what's in the best interest of the child. But a court overall, just hands down, is going to be, making sure that the child's needs are met, because the judges have a difficult job of making a decision for somebody else's child. And most judges I know, they want to do a good job.
Mm-hmm.
So, that's a really great question. One more thing I want to talk about, we talked a little bit about sole conservatorship, and that's making a decision, one parent making all the decisions for the child. And then there's joint conservatorship, where parents kind of, mix and match. Maybe one's making exclusive decisions for education. One parent is making exclusive on something else. Maybe they're making joint decisions for legal decisions, or they're making joint decisions for mental health decisions.
Mm-hmm.
So, but there's one more type of conservatorship other than sole conservatorship and joint conservatorship. There's possessory conservatorship. And possessory conservatorship has to do with time, possession time with the child. And so that is really what we speak of when we say visitation. Sometimes I'll have a client that says, I want to visit with my child. And so they're talking about their possessory rights. And so in Texas, we use something called a standard possession order, at least to get us started with the possessory rights. And it pretty much says visitation is as, mom and dad agree, and then absent an agreement, then you've got this nice schedule, which is pretty much every other weekend, every first, third, and fifth weekend, midweek visitation, Thursday, holidays, and summer. And so, that's the typical standard possession schedule. But then a lot of parents change it up. And that's the beautiful thing about, practicing law in Texas. One of the things I enjoy is being able to change a standard order to fit what the child needs, to fit what the parents need. So, like our firefighters, they're working 48-hour shifts. Our nurses, they're working 12-hour shifts. So sometimes those standard possession schedules don't work well for people like them, or some of our offshore people who are 20 days on, 20 days off. And so we might start with that standard possession schedule, but then we customize it to fit the needs of the child first, and then the parents secondarily. And so without going too much more deeply into these issues, what I'm hoping you'll take away is just how important it is to use the right terminology. Sole managing conservatorship, joint managing conservatorship, possessory conservatorship. And just know that for the most part, your judge is going to be wondering, hey, why shouldn't you be a joint conservator? Both parents should be joint conservators. And who's going to be the primary conservator? And so a lot of times at the courthouse, that's the fight. Who's going to be that primary? Who's going to designate the residence? But I have a little secret. You don't have to have a primary conservator if the parents don't mind. They can agree that, hey, there's not going to be a primary conservator. There's just going to be rights and duties allocated. And we agree our child's going to go to this particular school in this particular school district. And you can kind of do away with who's going to be the primary. And if both parents agree, you can oftentimes even do away with child support. So even though we've got these terms with agreements in Texas, there's a lot that you can do and a lot that you can customize for your case involving child. So, hopefully this has been helpful. Are there any other questions that you can think of, or any thoughts as we get ready to wrap up?
I mean, you seem to explain it like really well. But yeah, it's awesome that, you can come to agreements and stuff like that, and just do away with some of that stuff if it works for you. Out of my own curiosity, how often do you see that occurring versus more of that, no, I want to make sure that I'm the primary?
Well, I would say the majority of cases do settle. When there are fights or struggles for primary, there's usually deeper issues. There might be drug issues with the parent or the child. Someone might have a medical issue or some criminal history. There's usually some other complications that go with it. The majority of cases really do settle. Mediation is extremely helpful in getting cases settled and getting both parents close to what they want. But sometimes, when we have to take it to a trial or to a hearing, judges have their jobs cut out for them because they're usually complex cases.
Mm-hmm.
Yeah, so those are the exceptions. So, that wraps up today's episode and of our podcast and our discussion about conservatorship. Hopefully, you've got some more information on really what it means to have custody in the state of Texas. And if you would like more information, feel free to reach out to our firm. The contact information will show on the screen shortly. And also, if you've enjoyed this, if this has been informative, don't forget to subscribe to our podcast for more valuable information on family law. Until the next time, take care. And just remember, whatever you're going through, if you're going through trouble and you've got some family law issues, your family law is great, but also, don't forget to pray about it too, because God helps and answers everything. So with that, I'm signing off. Take care.
Thank you for listening to the Alsandor Law Podcast. If you need expert legal representation for matters about family law, the Houston Family Law Team at the Alsandor Law Firm is here to help. Visit alsandorlaw.com to learn more. Don't forget to subscribe, rate, or review our show and share it with others who might benefit from the conversations. Join us next week as we continue to explore crucial family law topics. Stay resilient and know that we're committed to supporting you every step of your journey.